Good day, Crime Talk aficionados. We have a great show for you today. First, Harvey Weinstein's convictions are reversed in California. Why? Oh, that thing that Scott hates, 404B evidence. Will we finally get some answers in the Suzanne Morphew case? And the judge makes some final rulings in the Karen Reed matter that starts on Monday. The prosecutors in the Bryan Kohberger case don't want to get caught flat-footed again. I'll explain. This guy should get the maximum penalty of whatever he is charged with. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. It is April 25th, 2024, and you know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that little bell for notifications, and remember, you can listen to us anytime on any of your favorite podcasting apps. All right, let's go ahead and get to the docket. First, yes, Harvey Weinstein. All right, let's just cut to the chase. We've been talking about this case for years. And in fact, I was going back looking at some of my comments over the years. And guess what? Harvey Weinstein was there. And what was it? 404B evidence. Okay, let's be perfectly clear. Harvey Weinstein is a horrible human being. He is a piece of garbage. He'd been properly convicted. Now his conviction in New York has been reversed. It starts all over again. However, he has still been convicted in California. And guess what? Same sort of theory of prosecution, throwing in a lot of 404B evidence, which we'll talk about in a moment. So guess what? That case may be coming back too. All right, so let's get to it. First, Harvey Weinstein, obviously convicted of rape. His sexual assault convictions have been overturned after the appellate court ruled that the judge made crucial errors in the handling of his case. Who said that years ago? Oh, that's right, this guy. Anyway, the New York Court of Appeals ruled that the movie mogul producer did not receive a fair trial when he was convicted back in 2020. Now, the ruling was made by the New York's highest appellate court there, and it was a plurality decision, which means it was 4-3. So one vote the other way, Harvey Weinstein would be sitting in prison for basically the rest of his life. But since it was 4-3 in his favor, he gets to start all over again. And the appellate court determined that Judge Burke, who had been handling the case, what is it with these New York judges? Anyway, they made a big error in allowing women who were not part of the case to testify. The court said it was an abuse of judicial discretion to permit untested allegations of nothing more than bad behavior that destroys a defendant's character but sheds no light on their credibility as related to the criminal charges lodged against them, the opinion states. And the decision obviously is a big step backward for a lot of people who wanted to hold Harvey Weinstein and others accountable for acts of violence. Now remember, courts routinely admit evidence of other uncharged misconduct acts where they assist the juries in understanding issues concerning the defendant's intent, modus operandi, scheme, absence of mistake. It comes in. We've talked about it. We'll talk about it more in just a second. But the jury was instructed on the relevance of this testimony, and overturning the verdict is somewhat tragic, a lot of people believe, because the victims have to go back and endure another trial. So the ruling came down. It was written by Judge Jenny Rivera, Chief Judge Rowan Wilson, and Judge Betsy Barros and Christina Clark. The judges who dissented were Judges Madeline Singas, Michael Garcia, and Anthony Canataro. They all dissented. Now, 3 judges did not participate in the ruling. So in a dissent, Judge Singas accused the majority judges of whitewashing the facts to conform to a he said, she said narrative. We'll talk about that too. Anyway, the majority's interpretation perpetuates outdated notions of sexual violence and allows predators to escape accountability, Justice Singhas stated in his dissent. The reversal of his conviction is obviously a setback to the Me Too movements in the last 2 years after the Supreme Court refused to hear the appeal of the Pennsylvania decision regarding Bill Cosby's sexual assault conviction. Coincidentally, why? 404B evidence. Now, remember, Weinstein denied the charges against him and insisted that he had relationships with all these women, but that everything was consensual. Then about 80 women came forward to accuse Mr. Weinstein of sexual assault and sexual harassment. And so obviously he was convicted, he got sentenced, then he went to California, got another sentence, and here we are. Now, if you've been watching this channel for a while, you know how I feel about 404B evidence. It is garbage. One of the fundamental principles in our legal system is the fact that you should be tried on these charges and these charges alone. And if you introduce 404B evidence, which is normally excluded as propensity evidence, basically you've done it before, therefore you must be a bad person, so you must have committed this crime. Today, we normally keep that out. But like the first thing they teach you in law school, to every rule, there's always an exception. But over the years, the courts have been paring back what is admissible because, once again, one judge thinks, well, this is a special circumstance, we're going to apply it to this case, and then it gets upheld on appeal, and then some other prosecutor goes forward with it and says, well, they did it once and that one, so it must be cohere. And it just keeps getting larger and larger and larger until ultimately, well, they're going to lose the relevant 404B because it's going to be thrown out at some point because everybody abuses it. And judges, for most part, are too cowardly to throw it out because they don't want to be perceived as the bad guy. Because I'm telling you, in criminal defense, ladies and gentlemen, if the case, the bulk of the case is 404B evidence of all the other wrongs that somebody has done, that means the underlying case that the prosecutor is charging and prosecuting is weak beyond anything, okay? We used to have this prosecutor, I used to deal with her all the time, and every case she would file, she would bring in every little petty conviction, even if it was convicted, even if there was an acquittal or a dismissal, she would bring it in to say, look, bad person. And finally the judge is like, are you kidding me? We're not bringing this in. It just gets ridiculous, okay? So now we had Bill Cosby that was thrown out, reversed because of 404B evidence, and now we got the Harvey Weinstein conviction in New York reversed, and California could go the exact same way. So really, ladies and gentlemen, you must seriously look at this. And I get it. In the trial court level, you've got the heated emotion. You've got the family. You've got the victims in the courtroom. Everybody hates that guy, which is great, unless, of course, it's you or someone you know, and they're after get that guy. And they just throw the kitchen sink at you. And, well, doesn't really care. He's a bad guy. And, in Harvey Weinstein's case, he was found guilty of some charges and not guilty of the other. So it looks like the jury was able to slice and dice some of the 404B evidence, but the appellate court said, this is absurd. This was egregious error. Egregious. And yet this judge, other than having her name in the paper that she committed egregious error, she'll have to come back. Now the prosecutors will have to decide whether they want to go forward with the case again, or maybe they cut a deal with the defense in this particular case, so they don't have to go through another trial again. But guess what? It'll be a much more pared down trial the second time around. What is really frustrating, and let's be clear, I am not defending Harvey Weinstein. He is a creep. He did all this crap on his casting couch, would take women to his suite to conduct business. I was looking back at something I was talking about how no legitimate person conducts business in their hotel suite, particularly with the opposite sex. You don't put yourself in that situation. You go down to a conference room. You have a boardroom. You have witnesses. You have glass conference doors. So there's nothing that can be interpreted as doing anything inappropriate or constitute sexual harassment anyway. You always bring a witness unless you're up to something nefarious and not good, okay? So Harvey Weinstein, I think he's scum. He's a sexual predator in my humble opinion based upon his convictions. We say that so we don't get sued. And so what it boils down to is, though, who is to blame? Is it the defense? No, it's not. You know who screwed this up? the judge and the prosecutor. The judge for not having the guts to say that's a little overkill, and the prosecutor for pushing the limits on what they could do. Now, I get it. They're going to say, we're trying to get justice for everybody. We had to do this. One of the jobs of a prosecutor not only is to seek justice, but it's also to protect the record so that there are not appellate issues. A good prosecutor will say, you know what? I don't need to push this. I got such a strong case. I don't need to push 404B evidence garbage down everybody's throat. All right? And a good prosecutor will say, you know what? The defense is right. It's not worth creating an appellate record that will result in potential reversal. So we will forego that evidence, Your Honor, and we feel confident enough in our witnesses in this particular case that we're charging that we don't need any of that 404B evidence. So we'll see. Go back. Anyone who's been watching me for a while, we have broken out the books. We have discussed 404B evidence. I have told you how heinous it is, that it is unfair, and finally, courts are finally starting to say enough is enough. So there's an easy way, ladies and gentlemen, and there's a hard way. Everybody always picks the hard way. And in this case, guess what? The state picked the hard way. They overreached, and now they have to go back and notify all of those victims that we may have to come back and do this all over again. And then they'll have to let a lot of the other people know, yeah, your testimony won't be needed because it will be precluded this time. And hey, if Harvey Weinstein is convicted the second time around, so be it. The general point is, ladies and gentlemen, if we let the government railroad the guilty people, they will start doing it to innocent people as well. So by protecting the rights of the scumbag Harvey Weinstein, he's actually possibly protecting a lot of innocent people, which could be you, your friends, your family. You never know. All right, next on the docket. Are we finally going to get some answers in the Suzanne Morphew case? Well, apparently the medical examiner has completed the autopsy of Suzanne Morphew. Remember the mom who went missing back in 2020 on Mother's Day, and her remains were not found until October of 2023. Like I said, the police announced last year that they had located Suzanne Morphew's remains in the area of Moffat County, in Seguchi County as well, about 45 miles south of her home that was in Maysville, Colorado, where, like I said, she went missing on May 10th. The Colorado Bureau of Investigation has confirmed that the autopsy is complete and that the Chaffee County coroner anticipates being able to release that report by Monday. I know, native of Colorado, Saguachi, Chaffee, still not sure exactly how it's pronounced. It just depends on which part of the state you're in, I swear. Even when you're in those counties, you hear people say it different ways as well. So work with me. It's not just Scott being unable to pronounce things, all right? And obviously the autopsy result will possibly, I guess in this case, possibly include a cause and manner of death, which will hopefully bring some answers to her disappearance and death some 4 years ago. Now, as you may recall, Suzanne Morphew's husband, Barry Morphew, was initially accused of killing his wife and was charged with her murder and tampering evidence back in 2021. And she was obviously presumed dead, that being Suzanne Morphew. Now, a year later, prosecutors had to drop the charges against Barry Morphew, saying that they wanted more time to find his wife's body. Well, in reality, the judge had accused the district attorney of a lot of discovery violations, and the case was looking like it was going to be dismissed by the court. So the prosecution stepped in and dismissed. Now, Barry Morphew has always maintained his innocence, and just about every district attorney that worked on that case has been grieved and is potentially looking at the loss of their license as a result of their conduct on the Barry Morphew case. And the attorney for Barry Morphew, which includes Miss Iris Itan, who has made the life a living hell for those prosecutors on the Barry Morphew case, has filed a $15 million lawsuit against those prosecutors, the investigators as well, accusing them of violating Mr. Barry Morphew's constitutional rights. Now, no other arrests have been made in the cases, and the charges against Barry Morphew were obviously dismissed, but the prosecutor could always re-bring those charges if there was enough evidence to link the cause and manner of death to Barry Morphew. I'm betting against that. Don't think that's going to happen. We'll wait and see, and we'll discuss it next Monday. Next on the docket, that Scott Peterson guy. This guy just won't go away. Anyway, the district attorney filed a quick response, and I mean quick 350-page response to say why the pleadings filed by Scott Peterson's defense team requesting DNA testing of certain items basically should be ignored by the court. Now, if you are old enough to recall this case, you know Scott Peterson was originally sentenced to death back in 2005, but that sentence was overturned in 2020 when the California Supreme Court ruled that potential jurors that were on the Peterson jury were improperly dismissed because they said they personally disagreed with the death penalty but would be willing to impose it depending on the facts and the law in the case. So in 2021, Peterson was resentenced to life without the possibility of parole, and now he is represented by the Los Angeles Innocence Project, which is not associated with the Innocence Project. And so now they are trying to return the conviction as related to his Scott Peterson's wife and unborn son. Now, Lacey, his wife, was 8 months pregnant when she disappeared on Christmas Eve back in 2002. And her body and the young fetus that she was carrying washed up off of San Francisco Bay back in April of 2003. So as I noted, the 300-plus page filing, the DA states that the 14 items that the defense wants tested have either already been tested, are unrelated completely to this case, or that the burden to have them retested has not been met by the defense. No ruling by the judge as of yet. All right, the upcoming Karen Reed case. Why? Why did somebody not tell me about this case? This sounds so interesting. I really had no idea this case was going on. There's only so many hours in the day. It's just Frank and I. But if you have an interesting case, send it to us, all right? Send it to us. Say, hey, what about this? I'll try to cover it. I promise. All right. So the Karen Reed case, the judge presiding over the case of Karen Reed, yes, the woman who accused of killing her Boston police officer boyfriend, has ruled on several motions, and the stage is now set for the opening statements on Monday. The judge confirmed that the trial will now be moved to a smaller courtroom after Ms. Reed's attorney expressed concern of the layout courtroom where the jury could not actually see the witness testify. That's big, right? You have to be able to judge the witness's demeanor on the stand, their credibility, their ability to recall what they perceived. It all comes down to being able to see people. That's how you do it. And if the jury, when they were sitting, would only get the back of the head of the witness, well, it really wouldn't be doing what our judicial system requires, which is they'd be able to judge the credibility of the witness. Now, the judge noted that since they are in a smaller courtroom, that the media, the actual trial participants, and family would be assured seating in the new courtroom, but probably that's about it. So, as we discussed the other day, Miss Reed is charged with running down John O'Keefe, her Boston police officer boyfriend, and then leaving him allegedly to die in a blizzard in the town of Canton back in January of 2022. She's pled not guilty to those charges of second-degree murder, motor vehicle manslaughter, and leaving the scene of a collision in connection with Mr. O'Keefe's death. Now, Reed's defense has argued that she is being framed and that O'Keefe was beaten and attacked by a dog inside the home of another Boston police officer where he was being dropped off at. And the prosecutors claim that a piece of hair found on the back of Miss Reed's Lexus implicates her in O'Keefe's death. Now, according to the judge, when opening statements get underway Monday at 10 a.m., the defense and the prosecution will each get 45 minutes to present their opening statement. Remember, opening statements are not evidence. It is a roadmap of where the jury can anticipate the evidence leading you throughout the process. Now, neither side will be allowed to use exhibits during their opening statements, and that makes sense because that makes sure that the jury doesn't see things that are not going to be admitted into evidence. Yes, it varies by judge to judge. Some say if you have a good faith basis that you believe the evidence will be coming in, or if there's a stipulation among the parties that you can use exhibits, then that's okay. Interesting to see that no exhibits are going to be used. Going to be an interesting trial. I hope I get time to watch it all, at least in the daylight hours. If not, I'll have to watch it in the evening because I got nothing else to do. All right, next on the docket. The prosecutor in the Kohberger matter doesn't want to get flat-footed. That's right. Why are you saying that? Well, the prosecutor in the Kohberger matter has filed a motion, and he's requesting to do a couple of things. First, he wants to close the May 14th hearing regarding the defendant's fourth motion to compel and any hearing to be set for the defendant's fifth motion to compel. Now, apparently in the defendant's fifth supplemental request for discovery that was filed under seal, the defense is requesting the discovery, and they ordered it all to be sealed, and the court has granted that. So therefore, it makes sense that they do that, okay? Although I think it all should be in the open court. That's just the way I think it should be, but it is what it is. Idaho seems to be really loosey-goosey when it comes to doing everything in private. And the prosecutor claims that there exists a compelling interest at stake to preserve a fair trial. And this is what I get. No reasonable alternative exists but to conduct a closed hearing. Really? No reasonable alternative. It just blows my mind. I can tell you, other than if there's an issue about attorneys getting off the case, like I said, I don't believe I've ever done a closed hearing. 30 years of practice, never lock the doors. Maybe a juvenile matter, something, there was some privacy interests. It just doesn't happen, ladies and gentlemen. It's unbelievable to me that that's how they conduct these hearings. You could do this in any case. Oh, it's going to be embarrassing to the parties. Well, it's a homicide case. I hate to say it, but there's going to be embarrassing things. It's just the way it is. And I guess they're so worried about information getting spread. But we already know that doesn't matter. I don't know. We'll just leave it at that. Doesn't make sense in Idaho. Anyway, the state further motions the court for a scheduling order setting May 3rd for the defendants to file any notice of witnesses, exhibits, experts, and reports or other evidence the defense intends to rely upon for the hearing regarding the fourth and fifth motions to compel. That's the important part, ladies and gentlemen. Because remember, they were having the hearing on the whole issue of whether the surveying should have been allowed to take place, right? The defense is like, we got a witness, let's do this thing. And the prosecution was, well, we don't have it. And we've talked about it. He wasn't prepared. He's filing this because he doesn't want to get burned this time again. He wants to be able to see and be prepared for the motions hearing and say, hey, I want to know what what witnesses you're going to have, if they're going to rely upon anything, etc. Because apparently the prosecution can't function without their safety net there. So very interesting. But on the other hand, it is fairness that if you're going to have a hearing, you're going to call witnesses, you should disclose all that stuff too. But I kind of like the good old days, like the Wild West, gunfighters. Let's just go in and let the chips fall where they may. It's just kind of fun sometime to watch. Anyway, next on the docket, WTF, man. This guy needs to get the maximum penalty. This passenger apparently starts brawling with a bus driver. Why? Because the bus driver apparently didn't stop or didn't hear the little ding ding when he was saying stop, stop. So what's the reasonable person to do? No, not just keep ringing the bell. Yeah, let's get up there. Mr. Tyrone, Tihron Harrison, starts beating the bus driver as the bus was moving, which would be okay, that's fine. He drags the driver out of the seat while the bus is moving. Now a passenger intervenes and pulls Mr. Harrison away from the driver. But don't worry, the bus slammed into a storefront to stop. Thank goodness the driver at least had his seatbelt on. Otherwise, he would have gone through the windshield. Anyway, Mr. Harrison, obviously realizing that he was correct in his conduct, stayed at the scene. No, he didn't. He ran from the scene, but ultimately was picked up and arrested. Now, obviously, the driver had a couple of injuries, but my understanding is that he's going to be okay. Now, my general thinking is send this punk to jail. This is not how civilized individuals behave. Hey, excuse me, driver, did you not hear? Ding, ding. Could you please pull over at the next safe spot so I could get off the bus? No, he starts beating the driver. Okay, why do we send people to prison? Because they commit violent acts. Usually because they have no impulse control. They just start beating people up, assaulting them. Dangerous, indeed. So, Mr. Harrison, you want to go around assaulting people for something of this nature? Guess what? You need to go to prison so that you are so old by the time that you get out, you can't hurt anybody. Now, obviously, that probably won't happen to Mr. Harrison. He'll probably get a slap on the wrist, probably a misdemeanor charge, but he should get the maximum penalty either way. Let me know. You think I'm just being ridiculous? I don't know. Maybe I'm just getting tired of this senseless, indiscriminate harm to people. Next, our dumb criminal of the day. Speaking of, this is not the way people function. Watch this video. Guy coming through the roof into the bakery. See the legs dangling down there? Guess what? Then he comes crashing down and look, ooh, now that had to hurt, right? I hope he got a couple of broken ribs out of that one. Now, this unidentified man who fell into this bakery, which specializes in Venezuelan baked goods in Chicago. Nobody knows who he is, but apparently the bakery is connected to an apartment complex. And the owner, obviously, this is their dream to have a bakery and to serve their goods to other people. And, what does it matter if you can't think, oh, it's safe at night. We lock the door and we turn the alarms on, but they're coming through the ceiling. Our unidentified baking burglar, well, I hope those ribs hurt. I hope they do. You are a dumb criminal of the day. All right, ladies and gentlemen, that's all we have. Thanks for watching. We'll see you next time on Crime Talk.